In this episode, we will be discussing California Landlord Tenant Laws. The following is a summary of landlord tenant laws in the state of California as they apply to residential rental property. Topics include disclosures, withholding rent, the right to enter, security deposits, eviction and termination, increasing rent, and more. Required disclosures. Sex offenders. Landlords must include the following language in their rental agreements. Notice. Pursuant to Section 290.46 of the Penal Code, information about specified registered sex offenders is made available to the public via an internet website maintained by the Department of Justice at www.meganslaw.ca.gov. Depending on an offender's criminal history, this information will include either the address at which the offender resides or the community of residence and zip code in which he or she resides. Shared utilities. A landlord must disclose whether gas or electric service to a tenant's unit also serves other areas, and must disclose how costs will be fairly allocated. Toxic mold. Prior to signing a rental agreement, a landlord must provide written disclosure when he or she knows or has reason to know that mold exceeds permissible exposure limits or poses a health threat. Landlords must distribute a consumer handbook developed by the State Department of Health Services describing the potential health risks from mold. Pest control. When the rental agreement is signed, a landlord must provide the tenant with any pest control company disclosure the landlord has received, which describes the pests to be controlled, pesticides used and their active ingredients, a warning that pesticides are toxic, and the frequency of treatment under any contract for periodic service. No smoking policy. If the landlord prohibits or limits the smoking of tobacco or marijuana products on the rental property, the lease or rental agreement must include a clause describing the areas where smoking is limited or prohibited. Notice of default. Landlords of single-family homes and multifamily properties of 4 units or less who have received a notice of default for the rental property that has not been rescinded must disclose this fact to potential renters before they sign a lease. The notice must be in the language of the negotiated lease agreement and must follow the language specified in California Civil Code 2924.85D. Security deposit limit. A landlord may charge a tenant the equivalent of 2 months' rent for the security deposit if the residence is unfurnished, and 3 months' rent if the residence is furnished. California landlords can also add an extra 1/2 month's rent if the tenant has a waterbed. Non-refundable security deposits are not permitted. Deadline for returning a security deposit. A landlord must return the security deposit along with an itemized statement of deductions within 21 days after the tenant has vacated. Advance notice must be given to the tenant before taking any deductions out of the security deposit, such as for the cost of repairs for damage to the property. Late fees. A late fee can be enforced only if the fee is a reasonable estimate of the amount that the lateness of the payment will cost the landlord, and if specific language is included in the lease. Increasing rent. Landlords must give tenants at least 30 days notice or 60 days notice if the sum of the rent increase and all prior rent increases during the previous 12 months is more than 10% of the lowest rent charged during that time. Landlords may not use a rent increase to retaliate. Withholding rent. Tenants may withhold a reasonable amount of rent relative to the problem. So unless the unit becomes completely uninhabitable, tenants are not entitled to stop paying the rent entirely. The landlord must be paid reasonable value of the rental in its unfit state or deduct rent based on the value of the part of the unit affected by the defect. Repair and deduct. Tenants may hire a professional to fix serious problems or do it themselves and subtract the cost from the following month's rent, but the landlord must be given a reasonable opportunity to be notified and fix the problem. If the landlord fails to act, then the following conditions apply. Tenants can't spend more than 1 month's rent. Tenants can't use the repair and deduct remedy more than twice in any 12-month period. And tenants can't have caused the problem, and it can't be something that is the tenant's responsibility. Terminating tenancy and eviction. A 3-day unconditional quit notice to vacate or face eviction may be used when assigning or subletting without permission, committing waste or a nuisance, or engaging in illegal activity on the premises. A 3-day conditional notice to cure or quit may be used on all other lease violations to give tenants a chance to correct whatever the problem may be. The right to enter. Landlords must provide a 24-hour notice of entry or 48 hours for the initial move-out inspection. For more information, additional laws and articles can be found at AmericanLandlord.com.